most of you have done or heard of short sales in the last couple of years. And if you've heard of short sales, you've probably heard of the name Stephen Beede. Stephen is one of the area's top real estate attorneys and specializes in short sales. So today we're fortunate to have him here at our office, and he's going to give us a presentation and talk about short sales. So welcome, Steve Beede.
Thank you, Steve. Anyone with a name like Steve as a start is going to be a good guy in my book. Although, you know, there was somebody back in Hollywood years ago that said every Tom, Dick, and Harry's name's Steve nowadays. So, well, today we're going to talk a little bit about an update on what's going on in the market, more particularly focused on what are the things that are going to impact your short sale success. The way I like to do this, I'm looking at my watch now, it's about 9:10. I'll go for about 40 minutes, then open up for Q&A. So if you have questions along the way, write them down, save them, I'll get to you. I will not leave before all your questions are answered, even though this meeting may come to an end. So what I want to focus on, by the way, how many of you have sent clients over to us before? A lot of hands. Thank you very, very much. If those of you I don't know, grab a yellow sheet if you haven't seen one. We have a $200 consult for your clients. And that's the important thing about that. That's that upfront gift that you can give to your clients, but don't give it to them. Make them pay for it. Because if they don't pay for it, it's worthless. You give somebody information. If they are going to buy into it, has value, they need to get some skin in the game. So that's one of the things we'll be talking about in the course of this is what that advisory service is that we offer. But today I want to go through this update. I'm going to modify from the yellow sheet, since you didn't get one. I'm going to modify from that sheet a little bit. There's really only three things that can go on when somebody's upside down on a property, right? They're either going to be able to keep it, or they're going to sell it, and if they can't sell it, what are they going to do? Lose it, right? So what we're going to do is walk through all three of those things, because when we meet with your clients, we're going to cover all three of those things because they need to know it. Now the easy one to get out of the way, sadly, is keep it. Most of the people that you're going to be dealing with or that contact you, they're contacting, they want to keep their home. But most of them, the sad reality is they're not going to get to. The modification process in the United States, primarily the HAMP modification and even the non-HAMP processes, are running at about a 4.6% success rate.
Wow.
That means those who apply will not get it, despite all they may be told. They will not get the modifications. Now, some will. So don't discourage your clients from applying. They might get it, some do. Now, of those 4.6 that get the modifications, 60% of those will fail because there's no principal reduction tied to it. It's so bad that the director of the TARP program that funds the whole thing has said this thing's a failure, we should shut it down. And several congressmen are obliging, and there's bills in Congress today to shut the entire loan modification HAMP, half of all of that, get it out of the way. It's a waste of money. So don't worry about referring your clients to loan modifications thinking, I got to get them in a short sale. No, they're not going to get the modification anyhow. So if you get them out there, stay in contact because they'll be coming back to you. And they'll thank you for having faith in them and encouraging them to at least try. So keeping it is really not on the agenda. I'm going to jump off the sell it so I can touch on the lose it part first. Now, that saves me more time to talk about selling it, right, which is what you do. The lose it, I'm touching there because there's three things going on that you've got to be aware of, because they impact short sale success, but the problem is with it, they're increasing the likelihood that the people will lose it. And three things that we see happening out there. One, no question about it, foreclosures are increasing. In February, Fannie Mae put out a directive to all lenders dealing with Fannie Mae loans, 90% of the market, that said you will not sit back and take your time getting these things foreclosed. You will act quickly. Within 3 days of somebody missing a payment, you will contact them. That is driving pressure in the market, particularly aimed at Bank of America, to get off the stick and get moving on these things. So that's coming out of Fannie Mae. That's driving foreclosure push. Bank of America, our great friends, have reorganized. Now, this you'd love. This is something the marketing people would have to come up with. Bank of America, you all know, is really messed up because of all the countrywide stuff. So they divided the company in two. One side has all the good stuff, the paying loans, the banking business. The other side has all the garbage. Now they named the garbage side legacy assets. Now doesn't that sound like something you want in your estate plan? Legacy assets. That's a good sound to it. You don't want these legacy assets. The reason they've done it is so they can start more expeditiously getting this stuff off the books. Unless they get the toxic assets, it's a good name for them, out of Bank of America's books, Bank of America is going to be languishing in the market in competition with everybody else. They have brought in to direct that side the guy that was running One West Bank. Now, if any of you know One West, they were created to take over IndyMac from FDIC, and along with that came a shared loss agreement under which they make more money foreclosing than they do short selling. That's the guy who's running legacy assets of B of A. What have we seen since then? 4 months out, we're seeing notices of default. That has not been occurring. The average out there has been 6, 7, 8 months. B of A is driving to the market in 4 months. That means the people that have Bank of America loans, by the way, you talk to people, they said, oh, no, I've got a friend, hasn't paid 2 or 3 years. Ask them who it is. It's Bank of America. Almost invariably that will be Bank of America. So that has been an incentive to someone to say, well, yeah, maybe I should short sale, but I want to milk this thing for a while. I'll wait it out, and maybe I'll give it a couple of years before I got to sell it, and that may be good, but those days are over. Now, it's not completely over. Bank of America still has too many bad loans to deal with. Here's what we're seeing, and here's how it impacts you. The people that have been getting the notices of default, that's the first step in a foreclosure, in 4 months, in some cases a little less. Where it seems to be coming in is where the gap between the first loan and the fair market value is thinner. By thinner, I mean $80,000 or less. When it's that thin, they may be making a decision, look, we can take this thing to foreclosure, maybe get some bidding going on at foreclosure, we get rid of the agent commissions, we get rid of the escrow cost, and our margin of loss may be less than if we try to do it through a short sale. That seems to be the thinking. If the gap between the first loan and the fair market value of the property is higher, 150, 200,000, there's a lot of those, nothing seems to be happening. So when you're talking with a client about a prospective short sale, and they've got a B of A first, look for the gap. How big is the gap between fair market value? Because that will give you an indication that these people need to get the property on the market today. I know you want them to do that, but they need to know that they need to get it on the market today. That's part of the counseling we give them. So that's an important change. The robo-signer mess last fall caused a lot of lenders to stop foreclosing. That is all over with. They're foreclosing. 2011 is going to be going down in records as what they call the year of the foreclosures. We'll have more foreclosures this year than any other year in history. Now, until about a month ago, we believed that we'd be through all this mess this year. I mean, it's tough. Let's get through it, get on with life. The economy has taken a dip. Where we were down, we came up, and we're leveled off here, we are now back down here. And until the economy as a whole gets straightened out, real estate mess is not going to fix. We're now projecting that foreclosures and home troubles are going to easily go through 2012. It may go further. I read something by economists yesterday. They're talking 2014. Now we know 2014 is the timeline for commercial property. I don't see in reality that residential is going to push out that far because most of the foreclosures, the bad stuff, will be done. But 2014 is the first time we'll probably see some uptick in prices. So keep that in mind. That's what's going on. The other thing that's happening with regard to people losing it in the foreclosure side, big change that's been happening in the past 2 weeks. Fannie Mae has had a guideline out there that says if there's a junior lender, we're not going to allow sellers to contribute to junior lenders. So if the first lender is going to give the junior $2,500 or $3,000, that's it. But junior lenders that may be saying, well, gee, I'll do better if I let the thing go to foreclosure. Yeah, I'll get wiped out when the first forecloses, but then I can sue them. They have all the leverage because nothing forces a junior lender to play along. And so they've been demanding that the seller contribute something, and now Fannie Mae and Freddie Mac have been saying, you can't do it. They're barring the first lenders from, they're barring the sellers from contributing anything to the junior lenders beyond what the first is willing to give them. And the result of that is, if they bar it, that short sale will not occur. That property will go to foreclosure. This week, we're seeing a lot of that occurring. So we're trying to figure out, how do you get around it? Well, what the junior lenders have been trying to push people to do is take it off the HUD 1. We'll just do a side deal. Give us the money outside of escrow. Been a lot of that going on. That's called mortgage fraud. And here's the reality. You're signing, you as agents and your clients in the short sale are signing a declaration on the HUD 1. This is the deal. It's all going to be right there. You do something over here and the first lender doesn't know about it, they'll find out. And when they do, not only is the seller liable for committing fraud against the first lender, so are the agents that participated, so is the second lender that induced it. And what could that mean? Well, what did the first lender not get because they didn't get the short sale? How about the entire deficiency? How about some legal fees and punitive damages? What if they referred it to the DA? Now, do I think district attorneys are ever going to bring criminal charges on this? Not really. They got enough problem with druggies. But could they? Yes. You don't want to go there. If there's a push from junior lenders to try to get you or your clients to participate in a fraud, don't. I know there's a lot of incentive to do it. If I can just get around this hurdle and get paid, I can pay my bills. Don't want to go there. Work around, try to figure out ways to go on. If those of you are not getting my blogs or checking my blogs, or getting my, if you don't get my e-news, put a card in there. Because when I send out, like I did yesterday, the blog on this change, I'm already getting feedback from agents around saying, this is what we did to get around it. Legal stuff. Looking at how a lender's responding to notes. What about discounted payoffs before you ever get into escrow? Things like that, and we'll be putting out probably within a week. I'll put out a blog and an e-news to everybody. These are the things that I'm seeing people dealing with, the junior lenders. It's critical that we figure out how to deal with that, or short sales are going to die. That's the reality. So, those are the changes out there that we see that are most impacting people to lose it more than they will to sell it. So now let's focus on the sell it side, because that's what we're here for. Let's talk about that. I already mentioned that the time for people to wait is over. That means there's an incentive to get in and get together with you and get the deal done. Here's the thing you've got to realize. People come into me, you refer them, or other people refer them, or they come from our blog, they're scared. They don't know what to expect, but they know that no good is going to come out of this. And so what are we trying to achieve? And here's the thing to understand. If a foreclosure occurs, 4 very bad things can happen to them. Number 1, a judgment could be gotten against them. That's not good. We've been talking about the seconds. That's where it's more likely to be. It's generally not going to be first lenders, but judgments are not good things because it can attach to their other assets, their wages can be going, all sorts of bad stuff. Secondly, debt forgiveness taxes. Anytime a bill's not paid, a debt is not paid in full, it's taxable income unless there's an exemption. Okay, that's a bad thing. Credit damage, oh gosh, it's going to be credit damage if somebody's not paying their loan, which is what it takes to get a foreclosure. So what's that all about? And fourth, that a lot of people don't think about, is career damage. There's 2 categories of people out there that have severe career damage. If they have a foreclosure, they will lose their job or their career. You got securities, military security clearance, policemen, firemen. They won't lose the job. The military's not going to kick them out. But if they're flying the SR-71 Blackbird out of Beede, they're done flying if they have a foreclosure. They will lose their security clearance. Policemen and firemen, they go into people's homes when they're not there. They may not lose the job. They will not get another one. Okay, take that. Then you get fiduciaries, bankers, stockbrokers, accountants, particularly if you're off the line, particularly bankers. If you have clients that are in that category and they don't know what to do, they cannot have a foreclosure. That's critical. So these are the type of things that will occur to them if they were to have a foreclosure, and they're all the things that can be mitigated or made less bad by a short sale. And so if you've gone through it, or we've gone through it with them, the analysis of what's going on, at every stage of that, the short sale will make it better. If they're at risk for a judgment, there's nowhere to negotiate with a lender to try to reduce that risk in a foreclosure. There's all sorts of room to negotiate that risk away in a short sale. That's what your clients need to know. The debt forgiveness tax is there regardless, potentially it's there regardless of whether it's a foreclosure or a short sale, but it will be less. in a short sale because the gap is less. Career damage. I'm told 100 to 150 points difference, but we do know if your client has a foreclosure, they're not buying for 2 to 5 years. If they have a short sale, 3 to 5 years. After a foreclosure, 2 to 4 in a short sale. That's better, but the biggest for a lot of people, short sale occurs, no career damage. That's critical. You got somebody out there that's young in their career, they don't know where they're gonna be in 5 years, they're moving up the ladder, they're applying for new jobs, maybe they're unemployed, trying to get a job. If they fill out a job application and it says, have you ever had a foreclosure? They may never get the job. The point is, they may be applying for a job, but the personnel officer's got 100 applications on the desk in front of them. All they're looking to do is get rid of them, and that's an easy screener. Or you had a foreclosure, you're out of here. So for a lot of people, the short sale has enormous impact on their future, not just on this debt. So that's the service that you're bringing. Clients don't realize that. When clients come into us for the $200 consult that we do in 1 hour, we walk through all of this with them because they need to know the answers to this, and we need to know how exposed are they. Because at the end of that 1 hour, they'll know strategically what to do. Now, what does that mean? Between 90 to 95% of everybody that we see is a good candidate for a short sale. If you refer somebody over to us, we get them right back to you, educated so they know what to do. More and more, it's going to be get back to them and get it listed now. Now that leaves another 5 to 10% of people out there that fall into really 2 categories that you need to know about before you ever approach a short sale. One, short sale isn't going to solve their problems. It's like the person that came in, they had $150,000 of charge card debt that they ran up trying to keep their house. They're going to be in bankruptcy regardless of whether the short sale is successful or not. They may be better off getting to a bankruptcy attorney anyhow and proceeding on that basis, because that's the only way they can get rid of their problems. Understand, if there's a bankruptcy, that doesn't transfer title. It's still going to be a short sale or a foreclosure. So just because someone files bankruptcy doesn't mean you're not involved in the transaction. It's still there. But the bigger one you want to know about is the strategic defaulters. I had somebody in a few months ago, and we went through this whole analysis thing we're talking about, and we got down to talking about the hardship application. You'd think by now everyone would understand what that hardship thing's all about, and talk about the hardship letter and income expense statement, and say, oh, and they're going to want your net worth statement. Well, why? Well, you're asking them to take a hit. They don't want to take the hit. They want to see if you can contribute to it. And if you got enough assets, they might just, and you won't contribute to it, they'll say, for you, we'll do this thing called the judicial foreclosure, because even if it's going to take us 3 years, we can collect. Here's an example. Client comes in, he's already been through a short sale negotiation for about 6 months, got the buyer. They're now filling out the hardship application, and he says, I don't want to give you my net worth statement. You think you're going to get the short sale through without it? It ain't going to happen. So I said, well, what's the problem? What do you got? He says, well, I got $600,000 in cash in the bank and 4 free and clear properties. The guy was $250,000 upside down on his home and didn't want to pay. And I said, you're not doing a short sale. Because if you do a short sale, the lender is going to say, pay it up. And if you say, I don't want to, they'll say, thanks for the information, now we'll sue you. Because they can't. It's just the odds of a lender actually doing a judicial foreclosure to get a deficiency judgment against a seller, it's minuscule. It's probably less than 1% on homes. For this guy, yeah, it's almost 100%. You need to know before you ever spend a minute more of time other than talking with them that if they're a strategic defaulter, you need to know it before you waste your time, because they will never close a short sale. That's part of that 5 to 10%. But 90% or more are always going to remain short sale qualified. So the big things that we see that are impacting that out there is, again, we talked about the junior lender contribution issues. That's a biggie. That's impacting in the marketplace. The changing sellers, we talked about the strategic defaulters. So there's 2 categories. Those who will never short sell, the strategic defaulters, and those who must short sale, those who have a credit impacted job. Big chunk of the market fits within those two. Couple of last things before I open up for Q&A. If you're not familiar with it, you're all familiar with the Morris rules that have taken effect? Mortgage Assistant Relief Services. A law was passed in, I believe it was March 31st. There'll be new CAR forms coming out. And basically it requires certain disclosures to be made to all prospective clients. And it regulates the type of information that you can say and promise with regard to dealing with upside-down loans. You, as well as attorneys, as well as anybody else that's advising somebody upside down, are offering mortgage, what's the right acronym for it? Mortgage Assistant Relief Services, in a sense. Brokers can fall within that. You will have a Morris disclosure on a CAR form you want to make sure you're using. Read it. It makes logical sense. But the scammers out there that have been shut down by state and federal laws, it doesn't mean, even though they pass laws, it doesn't mean the scammers are not still there. So you need to be making sure that you're not making disclosures in your emails or in person that don't coincide with what's on the Morris disclosure. You don't want to get sued. Now, generally, I haven't seen anybody doing any kind of lawsuits like that, but those suits trail in a long time later when somebody loses their home and they say, oh, must be your fault. Or, you didn't tell me that, sue me, must be your fault. We're seeing an uptick in lawsuits that are coming in against agents. There hasn't been much lawsuits by lenders so far against upside-down borrowers, but buyers suing agents saying nobody disclosed these issues to me. They sue the sellers too, but the sellers don't have anything, so that doesn't matter. It's the agents that have insurance. So lawsuits against agents by buyers or by sellers are picked up. If you get somebody complaining about stuff like that, let your broker know right away. Within a certain amount of time, you have to let your E&O carrier know. We represent a lot of brokerages in these. Generally, we can knock them out fast. But if there's some endemic problem that's going on that you know because this is the way we've operated, we may be seeing more, you want to know it to correct it within your company so it doesn't come back and bite you. Morris disclosures are a really important thing. The other thing people have asked me about is two things, and they're coming up. One, you all familiar with the carbon monoxide detector law that's taken effect July 1st. July 1st, all single-family residences must have a carbon monoxide detector in there. It's not a big deal, but it's law. You have to have it. But if you don't have it and you sell it, it is not going to invalidate the sale. If it's sold and it doesn't have it in it, there is a $200 a day fine for not having it. But they can't impose it until they're giving you 30 days notice that you got to do it. It's really not a biggie. It's just your point. When you're doing your real estate agent transfer disclosure inspection, take a look for carbon monoxide detectors. They cost between $15 to $26. It's not a break a deal type thing, but part of your TDS disclosure may be checking to make sure they're there. Put that in your mind. Okay, the other thing I want to touch on and end with a little bit before I open up for Q&A, because people ask me all the time, Steve, it's gone sideways. The lender won't do what they say they're going to do. Can we just sue them and stop them? Okay, lawsuits to stop foreclosure. Very, very, very little success in the courts. There's scammers all over the marketplace out there that are saying, give us $5,000, $6,000, $7,000. We'll stop them. We'll sue them. It's a great line from lawyers. We'll sue them. Anybody can sue anybody. What really matters is, can you win? And what the scammers out there are doing is saying, give us $5,000, $6,000, $7,000 and give us your monthly mortgage payment that you give to the lender. Give it to us, not us, but these other law firms, and we'll stop them in their tracks, force them to do what you want. Those companies are being shut down by the state of California. The State Bar of California is just barring attorneys for that. They're still out there doing it. I had somebody call me just yesterday, upside down on the loan, and said, a lawyer contacted me from, I think it was San Diego. They want me to give them $7,000 and they will file a lawsuit to stop the foreclosure. The courts are not supporting it at all. Now here's some specific categories that may impact you where they're not supporting it at all. Well, this one doesn't impact you too much, but I got my loan modification. They told me I had it. I qualified for everything. It turns out all they got was the trial modification part. But they promised me I qualified for everything, and they're foreclosing anyhow. The courts are saying, too bad. You don't have any private right to enforce federal law, to enforce HAMP. So, people that qualify for loan modifications, if the lender doesn't give it, there's nothing they can do about it. Next, you got a short sale about to close. The negotiator says, well, we're going to tell the trustee to continue the trustee sale. And then they don't. Can you do anything about it? No. The only way you can do something about it is if some new contract has been made with consideration, like the lender says, okay, borrower, give us $1,000 and we'll continue it a week. Now you get consideration for a new contract. That's enforceable. Absent that, as the court said, a gratuitous promise by a lender to extend a foreclosure is just not enforceable. Courts will do nothing about it. But it's really even sadder than that. How many of you remember Charlie Brown's Christmas? You know, Charlie Brown gets ready, is it Thanksgiving, when he's going to kick the football? And Lucy's holding the football for him, and he thinks the world's all right. And he goes up to kick, and Lucy pulls the football away, and he ends up on his back. That is what is happening to people in the courts today. Twice in the past 3 weeks, we've seen this occur. Foreclosure is about to occur. The people have done everything right. They got a short sale ready to close. They got a modification they're qualified for. They get an attorney, throws a bunch of money at it, files a lawsuit. They ask the court to give them a temporary restraining order. That stops it right then and there. Now, everything I just told you said the court shouldn't award that, right? The courts are giving them a temporary restraining order anyhow. But all a temporary restraining order is temporary. It's good for maybe 2 weeks. So the court says, okay, we'll give you the temporary restraining order. It stops the foreclosure sale. The trustee cries a continuance for a little period of time. But the people think, I won! I got the restraining order. They're slapping the attorney on the back. Then they come in 2 weeks to get the injunction to keep the case going and keep that stoppage through the rest of the lawsuit. Invariably, the courts are saying, no, you don't have any legal right to an injunction. So we're denying it, and then the lenders immediately foreclose. It's very much the Charlie Brown thing. You think you won, but you really didn't. That's the thing that's going on in the courts today. So lawsuits to stop foreclosure are not going to find any real success out there, unless they really screw up. Now, we've had 2, as we speak today, one yesterday and one being finished off today, where we have actually gone after, threatened the lawsuits against the lender and gotten them to back off. In both cases, well, we've had some who've gotten the foreclosure backed off, but in 2 cases we had, the people already had, one, a loan modification that was in place, being paid, and the lender foreclosed anyhow. Another, a short sale, all set to go, the money's sitting in escrow, the lender foreclosed anyhow. In both cases, we were bringing wrongful foreclosure actions against the lenders. In both cases, because the foreclosures occurred, both cases, one, the lender rescinded the foreclosure, put the property back into people's name. 2, wiped their credit clean completely of any derogatory information. 3, paid all the legal costs. So then, in the one that was in the modification, gave them a better modification than they had when they started. That's pretty sweet, didn't cost them anything, they had to pay us, but it all comes back. The other one, the client said, oh, I don't want the property back, but you really messed around with me. In that case, the lender's giving them $10,000 for their trouble, plus paying all the attorney's fees, and wiping their credit clear like the loan never existed. Now, if the lender forecloses and nobody goes after them, the lender's not going to reverse anything. So it can be done, but it's got to be done in the right context. Legal value and legal assistance can really pay off. So lastly, before I open up for Q&A, and I got my pad, by the way, here, in case you stump me with something, I'll write it down and figure out what it is and get back to you. But my job here today is not to make you attorneys. Your job is to be the beacon of hope out there, to give people some ability to say, can I get this thing done? Can I save my job? Can I save my credit? Can I get back in later? When will that be? What do I have to go through the steps? That's your job for that. My job is to tell them what all the legal ramifications are of where they are. My job is to help them find the strategy of what's going to befall them and how do they make it better. My job is to tell them when they're exposed to a judgment, to taxes, to credit damage, career damage, and tell them how they can make that better. 95% of the time, that's going to be a short sale. Your job is just to put it into reality. So you're the hope. I'm the strategy maker. Together we're a team getting them from here to here, where they can move on. So I appreciate the opportunity, and we really value that opportunity to be part of that process. For those of you who don't know me, before I was ever a lawyer, I was a real estate broker for 30 years. I've been in that chair. I come at the practice as someone assisting the brokerage community to be more effective. And think of us that way, use us that way. And that's why I think we're best to be assistants to you.